Well, good afternoon again for those of you who've joined. My name is Peter Day, and today we're going to be talking a little bit about the Schrems decision from the European Court of Justice that was handed down just a few days ago. Oops. So we are going to get started. Just to introduce myself quickly here, my name is Peter Day. I lead Mixpanel's global privacy and security teams. I'm a former privacy officer for the United States Federal Reserve System. And I have a Juris Doctorate from Indiana University's Maurer School of Law, and by way of hobbies, I'm an avid surfer. And today I'll be speaking with you all today, and hopefully we'll have lots of engagement. This is meant to be a collaborative discussion, but we do have a few housekeeping items that I would like to go over. So the question portion of this, and we are really hoping that that will be the bulk of today's discussion. You can submit questions via Q&A function in Zoom, or you can use the Zoom chat function. We will be monitoring both. My colleague, Charlie Winchell, will be moderating the question portion at the latter half of today's presentation. This webinar is being recorded, so for those of you who are interested in having a copy, or if you'd like to share it with colleagues, we will generally try to get a copy out to you within 24 hours of the presentation. But again, today's webinar will be recorded. If you are having technical difficulties, trouble hearing, you can check the audio settings in Zoom. There's a little caret next to the microphone icon. You can also connect to the webinar via telephone if you are having problems with Zoom. One of the features that we'll be discussing today is that there is a lot of uncertainty and things are developing. And so your questions may also develop. And so we felt it would be beneficial to submit, to allow for the submission of written questions, which my privacy team will be happy to work on answers for via our community page at Mixpanel, a service that we call QBQ. So if your question isn't answered today, if you have an additional question later on that we can help with, please feel free to submit those into our community page via QBQ. Also, any questions that we don't answer today, we will collect the question and we will be posting answers to those on our QBQ website. So it's a great opportunity to get some additional content and help build our collective body of knowledge. That said, I did want to remind folks that we aren't really providing any legal advice today. Although I'm a US licensed attorney, nothing that we're going to be discussing today will constitute legal advice or specific guidance on the application of the Schrems decision or any other aspect of privacy, data protection, or European law. This is mostly just an opportunity to talk through issues, share ideas, and to collaborate on potential responses. So with that, I think we'll dive into the meat of the webinar. So the big headline here for those of you who've been following along is that Privacy Shield is gone. And to many of us, we in the United States, we woke up last Thursday to this news. Many of you saw it early to midday in Europe, and it was pretty shocking for those of us in the privacy field. It was not an expected result given the way things have been going, and particularly the way that many people had read the tea leaves up to that point. So the decision to terminate Privacy Shield, just to set the context here, came about in a decision by the European Court, or excuse me, the Court of Justice for the European Union, the CJEU. And it had actually been, and we'll discuss this a bit later, something that had been building really since 2013, and a long-running dispute between an Austrian privacy advocate named Maximilian Schrems, the Irish Data Protection Commission, and Facebook. I think the question that many have been asking and wrestling with since the decision came out is now what? What does this mean? What does it mean that Privacy Shield is dead? What does it mean that standard contractual clauses remain intact? What does it mean for transatlantic data flows? What does it mean for data transfers in general? And that's what we're going to dive into today. And the hope is that we'll be able to answer your questions. We'll also be able to look at some options and discuss options, weigh some of the merits of various options. But I think to do that, I wanted to set the stage a little bit. I wanted to explore some baseline understandings of what's driving the CJEU decision and the background on that decision so that you have the full context as you consider your options. I thought I would start that context part with understanding who is Schrems. And I mean that in the sense of where does this case come from? So the case here really begins in 2013, although the instant case began much later. To me, this begins when Max Schrems files his first complaint against Facebook under what was then called the safe harbor. The timing of the case, though, is important because it overlaps directly with a series of disclosures by Edward Snowden about the PRISM program, a National Security Administration intelligence gathering program that has caused a lot of waves and continues to cause waves. So I think it's important to understand that the roots of Thursday's decision really lie back in 2013 and really lie back in the Snowden revelations. Following Schrems' first case in 2015, the CJEU struck down Privacy Shield's predecessor, the so-called safe harbor, but almost immediately after they struck it down, Schrems filed a second DPC complaint, and this is a complaint with the Irish Data Protection Commission, again alleging that because Facebook participated and shared information with US intelligence agencies, or more specifically, was capable of sharing information with US intelligence agencies, it did not live up to the standard contractual clauses which it had used to replace its participation in the safe harbor. During this time, in the pendency of Schrems' second complaint, the US Department of Commerce and the European Commission entered into the Privacy Shield framework. And this was an adequacy determination that allowed for data transfers between between the European Union and the United States as an exception to the general bar on sending personal data out of the European Union. Following Schrems' initial complaint, there's an important sort of pause in 2017, and that's where the Irish High Court, the Irish version of the US Supreme Court, referred this matter up to the CJEU. And it did that to clarify questions of fundamental rights, specifically around what had now become the Privacy Shield framework and standard contractual clauses, which we'll talk about in a moment. And then obviously, the CJEU's decision just recently to strike down the Privacy Shield, but to uphold standard contractual clauses, which was the stated basis upon which Facebook, the real party in interest here, was transferring information to the United States. Stepping back and looking at the totality of this timeline, I think it's important to note two critical dates. One is the Snowden disclosures, and the other one is the Privacy Shield framework in response to the first Schrems decision striking down the safe harbor. And so today, though, we are going to focus heavily on the CJEU's most recent decision, but I think having this background illustrates the fact that we're looking at a trend line that has really put pressure on transatlantic data flows, especially around the disclosures that Edward Snowden made back in 2013. So what did the CJEU say in its decision on Thursday? So I think the first thing that we want to call out in the headline we have called out is that the Privacy Shield framework fails to protect fundamental rights. It fails to live up to the obligations to provide essentially equivalent protections to European data subjects. This was found particularly to be that it lacked a proportional collection, that the US law lacks proportional intelligence collection practices. That means that US intelligence agencies collect far more personal data than is needed to complete their missions in the eyes of the in the eyes of the CJEU. US law also lacks an effective mechanism for judicial redress for non-US persons. We think and have focused heavily on the decisioner's focus on adequacy. And that means that the Court of Justice for the European Union does not feel that US law is adequately protective of non-US persons' fundamental rights to privacy. However, we think that the enforcement of this particular finding is going to be uncertain, at least for the next several weeks, and is going to depend upon individual DPAs. So although Privacy Shield is gone, we don't know exactly what's going to replace it. In an interesting twist, the CJEU declined to strike down so-called standard contractual clauses, finding that they do provide an adequate level of protection, but you may need more, and we'll talk about that in a moment. We also saw in the decision that the court is focusing heavily on what we call essential equivalence, and that means that the SCCs are deemed to provide the same, or at least essentially the same, levels of protection to data subjects that they would get under European law. However, we also would note that the court, in its decision upholding SCCs, envisions a much larger role for data protection authorities, national authorities, pre-transfer assessments, and other proactive measures beyond just executing SCCs. And finally, I think it's important to note that while SCCs and Privacy Shield have garnered the bulk of the press and bulk of attention, there are other mechanisms for cross-border data transfers under the GDPR, such as binding corporate rules, transfers with consent, and other adequacy determinations to third countries beyond the United States. Again, time will tell if those other derogations and opportunities are a threat, but for now they were left untouched by the Schrems decision. One of the key questions that I've heard many of my colleagues discussing, and many of those who I've had a chance to speak with about the Schrems decision, is what has the regulatory response been? Obviously, the CJEU's decision speaks for itself, but it's been a real question about how it will be enforced and whether or not enforcement will occur immediately, and there's been a wide variety of approaches to that. I've highlighted some of the key ones here, but these are coming fast and furiously, so it would be impossible to update you about all of them. The key takeaways here is we are seeing a spectrum of response. The European Data Protection Board, which in my mind is an important player in this, has yet to issue a fulsome response. They have welcomed the decision and signaled that they plan to provide additional guidance and support. And we see the United States Department of Commerce, for those of you who are Privacy Shield certified, essentially saying that they believe that the Privacy Shield framework continues to apply to participants, and suggesting that the American FTC could take enforcement action if companies fail to live up to their framework obligations. The United Kingdom has taken a very sort of interesting approach where they've said that they want to continue to support transatlantic data flows, and they really want to equip UK companies to be able to participate in the global information sharing economy. And on the other end of the spectrum, you have the Berlin Data Protection Authority in a press release saying that they feel the decision means you cannot send information, even via standard contractual clauses, to the United States. And you've seen some in the last couple days, several other German regulators take a similar approach. So what are we thinking that you should do now? And again, we are going to open this up to questions. And so if there are other questions or more fulsome questions you'd like to discuss, options, we'd love to hear that. We think it's important to stay calm. When the safe harbor was invalidated, there was also a mad rush to try to figure out how do we get information out of the European Union. And it was unclear for at least a month after that decision where the dust would settle. So we think it's important, looking at the trend and looking at the background of the Schrems saga, that you stay calm, and that there will be some clarity that will emerge in the next month or so that will allow you to make proactive decisions about how to manage your cross-border data flows. That said, we are recommending that you consider executing SCCs for any processors, sub-processors, or joint controllers that you're currently in a relationship with. It seems like it's time to do that and time to take proactive steps. However, we would also note that this is not just a check the box exercise. The mere fact that you have SCCs is probably not sufficient anymore. There does need to be a little bit more diligence that's done. You need to perhaps do another analysis about whether there are additional safeguards in place, whether there's information security safeguards in place, and whether you can satisfy yourself on a risk-based approach that your counterparty, be it a controller, joint controller, processor, is taking data protection seriously. So that ends the sort of broader part of our presentation today. Again, we wanted to save as much time as possible for your questions, and I am going to hand it over to Charlie to manage those questions.
Great, thank you, Peter. That was excellent. For our audience, just a reminder, you can use that chat feature, or that Q&A feature, to submit any questions. Do have quite a few that have come through, so I'll just start with the first one here. What should European companies, in particular from Germany, that have subcontractors in the US do to stay correct privacy-wise with it, since the EU to US Privacy Shield is no longer valid?
Wonderful question, and very timely. The challenge that we're seeing in Germany stems largely from the fact that each German federal state has its own data protection authority, and those have run the gamut of what we've seen. The Berlin decision, I think, is an important one. The Berlin Data Protection Commissioner issued a press release, a non-binding press release, stating that it was their opinion that you could not send data to US-based processors, particularly processors utilizing cloud infrastructure, even with an SCC in place. But again, that decision's not binding. It was just a press release. We've also seen some other German states take a more, what we think, appropriate response, which is execute SCCs, conduct a risk analysis or risk assessment in line with Article 45 of the GDPR, which assesses the adequacy of the country that will be receiving the data, and then transfer information to that country. But again, I think it's important to note that the guidance coming out of Germany so far has largely been in the form of non-binding press releases and is very, very diverse given the number of data protection authorities. So I think step one, to answer your specific question, execute SCCs with all of your joint controllers, all of your sub-processors and processors, and then pay close attention to the guidance that's emerging out of the German DPAs, especially the German DPA that's in your state or region. And finally, pay close attention to the European Data Protection Board. If the DPA authorities in Europe are going to maintain the GDPR's core mission, which is to harmonize data protection law around the Union, they will not be able to tolerate a country like Germany or a country like France or any other country having wildly divergent views on how to enforce the Schrems II decision.
Awesome, thank you, Peter. All right, we have our next question here. It says, we are running a live chat software, dashly.io. Do we need to block our chat before the visitor confirms any privacy form?
So this is a slightly different question beyond the Schrems question, but it is a good one. I would suggest that when you are looking at the chat function, you need to understand if it is interacting in any way with the end user's computer, and particularly storing, even in volatile memory, any type of information that you'll need to access. That said, because you will be ostensibly collecting some personal data from the chat subject, perhaps their username, perhaps their name, perhaps their email address, depending on your use case, which you would know better than I would, it would be our general recommendation that you do obtain some form of consent prior to participating in that chat, particularly for European data residents. But again, the details would matter there. That would be a great question to post into QBQ, and we can give you a more fulsome response.
Awesome, thank you. And again, that link to the QBQ will be shared out in the emails following this webinar. All right, so for our next question here, in the event that you're relying on the Privacy Shield as a transfer mechanism to a cloud provider, is it lawful for the cloud provider to charge you to migrate data to an EU data center to remain compliant?
Terrific question. That is something that would depend largely on the commercial terms of your partnership with the cloud provider. It is lawful for companies to charge a reasonable fee under the GDPR to comply with various laws and to meet various types of requests. I don't know the specific content of that question, But again, I would say that it is not unlawful for them to charge. You may, though, want to look at that cloud provider, and consider your commercial options if you feel they are being unreasonable. But there's no part of the GDPR that specifically limits rights to commercially charge between a processor and a controller for the provision of processing services, the provision of hosting services, things like that. There are limitations on what you can charge individual data subjects, but commercial relationships are treated a little bit different.
Thank you. All right, next question. It's a bit long, so bear with me while I share all the details here. We're a service that provides websites with tools like live chat, chatbots, pop-ups to engage with website visitors. Our customers collect their website visitors' contacts and data via our service. In terms of GDPR compliance with party, us, or our clients, should we be responsible for consent collection and storage? And what are the requirements for consent collection and storage? And what data should be presented if requested, for example, by authorities or website visitors?
Yeah, there's a lot there. That is a very large question.
Great question.
It's a really good question. I think let's start with the earliest parts of who's responsible for what. I think that's really the gist of that question. Generally, if a service is flexible and moldable and placed in the hands of your customers, and they can configure it, control it, determine how it's used, deployed, how the data that's collected via your tools is sorted and made available, it's arguable that they are the controller. And that means that they typically are responsible at the end of the day for ensuring that they've received appropriate consents, that they've given notice about their data collection practices, and that they've ensured that visitors to your sites' fundamental rights are protected, and all of that. And so I think that's an important first question is, do you feel that your customers are controllers, or do you see that you're the controller where you're the company making those kinds of decisions? If you're the controller, then you would have to provide notice, and you'd have to be able to have what we recommend are just-in-time notices saying, hey, we are going to be collecting this. Do you consent? Can we have your consent? I don't know the precise natures of your technologies, and a lot of this would depend on that. But if you are using cookies and things of that nature, you would probably want to make sure that at least your customers have cookie banners, and that you have an ability to honor opt-out consents, or excuse me, opt-in consents. So you're not pushing content without having an affirmative action on that cookie banner. User comes and says, yes, I agree to cookies, or yes, I agree to tracking, whatever you want to describe it as, but we would strongly recommend that you have affirmative consent prior to pushing that content. And then as to your downstream uses, those really need to be set out in your privacy disclosures. And so if you say, this is what we're going to do with your data, this is how we monetize it, this is how we store it, share it, it's where we send it, all of those things need to be set out in your notice. And that combination of telling you, of one, understanding who's in control of the data, giving users an opportunity to consent to its use, and then being transparent about what you're doing with the data should provide the key ingredients for you developing a GDPR compliant framework. Again, there's a lot of nuance there and devil's in the details. So we would strongly recommend that if you have a chance to talk to your own privacy lawyer who could really help you draft a response. But that's incomplete, but hopefully high level framework for you to think through.
Excellent, thank you. Next question is, can we continue business as usual? We had just received the Privacy Shield approval and had made the necessary privacy changes 3 days before the Shield was struck down.
I feel for you. I'm so, that must be very, very frustrating. I would personally be very frustrated with that timing. So the answer is a little bit different on the US side of the fence and the European side of the fence. So starting on the US side of the fence, because you are registered with the US government agency, having gone through all the Privacy Shield frameworks and likely having updated as is required under the frameworks, your privacy notices, it would be our strong recommendation that you continue to participate in the program, continue to abide by the frameworks, utilize the frameworks as a control guidelines, at least until the US Department of Commerce either deprecates or issues further guidance. Secretary Ross, the Secretary of Commerce in the US, has been pretty explicit that he feels the framework remains in effect. And the US FTC, the primary enforcement agency, has hinted at the same. So to avoid legal risk, we would say continue with the Privacy Shield framework in the US. In the EU, I think it's a different story. And I think there, we would strongly recommend looking at SCCs and as more regulatory guidance comes out, starting to look at how to assess your processors and joint controllers and any sub-processors for participation in SCCs, and then looking at their data control mechanisms, looking at how they protect information, looking at encryption in particular, to see if you can continue to work with them under the Schrems decision. But I think for now, the short answer is you probably have a month, maybe 2 months, where there isn't really going to be any regulatory action taken for companies that are continuing to transfer under their Privacy Shield framework. Again, that could change tomorrow, but that's what we see is happening.
Great, thank you. All right, our next question here is, are there signals that there may be a Privacy Shield 2.0 where incremental mitigation is agreed to be put in place by the US or EU authorities because they haven't struck down SCCs?
Yes, there are. In fact, Wilbur Ross, again, the Secretary of Commerce, has said that he's already been in touch with the European Commission prior to the Schrems decision about what would happen if the Schrems decision was struck down. There has been a fair bit of talk about other options for transfers like what the Privacy Shield allowed. I think the challenge is the Schrems case hinges on 2 pieces of US law. One is something called the Foreign Intelligence Surveillance Act, Section 702, and the other one is an executive order from the Reagan era, Executive Order 13222. And both of those allow the United States intelligence agencies to intercept information from non-US persons, and that's a term of art, non-US persons, which basically means someone who's not a citizen of the United States or not legally in the United States, because those folks don't have legal rights under the 4th Amendment to the US Constitution. And so I think given that sort of fundamental disconnect in legal frameworks, it's going to be really challenging to find a Privacy Shield 2.0 that meets all of the Schrems objections. That said, Max Schrem's first case was in 2013. It took him until 2015 to strike down Safe Harbor, 2015 to 2020 for Privacy Shield. So, maybe we could get a couple of good years out of a Privacy Shield 2.0. So, fingers crossed for that one. I think it would be the best possible solution.
Thank you. All right, we have our next question. There's a couple similar ones. So just to kind of summarize here, we have a few questions around how does Mixpanel offer SCCs nowadays, and also what our localization offerings look like for storage in the EEA. And then also in the case of the US, how a company would be covered on top of SCCs.
Sure. So I'll take these all as a flavor of what do we do if you're working with a company like Mixpanel? So Mixpanel has invested quite heavily in a privacy program, and we've seen for a number of years a trend moving towards what we call data residency or data localization requirements to create a global privacy strategy. And so in light of that, what we've done is we've stood up a dedicated EU cluster, which means we can provide our service entirely in the Netherlands. And that means that you don't have to send information to the United States for core processing purposes. That said, it's a residency program. It's not a perfect localization instance. Some information such as billing, utilization, development, and support may be provided in the US, but we feel that because your customer's personal data is stored and processed entirely in the European Union, you'll really be able to reduce your risk surface by using a program like our data residency option on what we call the EU cluster. So the way we've been approaching this is we've been encouraging customers who are interested in this to look at our EU residency option and then to sign SCCs that will allow for very minor amounts of personal data to be transferred to the United States for processing. And why do we think that's appropriate? Well, looking at the Schrems decision, we see it's largely based on the risk to fundamental rights and whether you can use SCCs to guarantee that those rights will be protected. And we think that by taking the bulk of your personal data and keeping it in Europe and having a very minuscule, low intelligence value amount of data flowing to the United States and protected by contract, I think that will satisfy an adequacy determination that the court in Schrems was looking at. And so we think that that is a very defensible program and one that we've invested in heavily. And then finally, there was a question about whether Mixpanel as a company is accepting SCCs, and the answer is yes, and we always have been. So if you're interested in signing an SCC, you can reach out to your account rep if you have one. You can write into our compliance @alias, but we will be updating our online terms here in the next couple of days, actually, to expressly incorporate SCCs by reference into our online data protection addendum. So short answer, or long answer to a short series of questions, but Mixpanel is ready for this, and we're prepared to partner with anyone who's interested in using our service to come up with a solution so that they can continue to drive innovation.
Excellent. And a follow-on to that references integrations that we might have. For example, if you're sending data to Mixpanel via a CDP such as Segment.
That's a more challenging question. Mixpanel is in the process of looking at how to move folks using CDPs, aliasing, and other types of features of CDPs onto the EU cluster. And we're working closely with our partners in that space. I think that would be something that would be a great sort of follow-on for CPQ, or QBQ, excuse me. But the short answer is right now we're working on it. We don't have an active solution ready to go today for partners like Segment or partners like Optimizely or other CPQ, or excuse me, content delivery management systems.
Great, thank you. Little bit of a change in focus. What kind of practical steps can be part of a execute SCC move? So
I'm going to take that as kind of a mechanistic, like what do you need to do to get SCCs in place? And I think it depends a lot on your business model and how you've contracted with your customer base. We think that, and many of my colleagues in the field have argued for, that SCCs can be incorporated by reference into existing data protection addenda. And so you can put in place the SCCs, which are available, incidentally, on the European Commission's website, and they are not to be changed when they're negotiated. There are some commercial terms, but they need to be present in their totality. Those can be incorporated by reference into existing DPAs, and then provided that you can get some affirmative inkling of consent, be it a checkbox, possibly a signature, or something that shows that your data subject or your controller or whatever the relationship that you're having with that party has agreed to the SCCs as a valid mechanism of transfer, you can then begin to transfer under the SCCs. So we've taken an approach here where we've looked at tiering our commercial relationships. So obviously those of the processors of ours, so people who process our data, we've started with them and affirmatively reached out to them, asking them to execute SCCs. We've then gone on to our second tier vendor base, asked them to start executing SCCs, and we are in the process of working through our customer base as well on SCCs. And then obviously we'll be updating our online terms here in a little bit to handle standard contractual clauses. So to sum up, you can incorporate SCCs into existing online terms. They can be incorporated into data protection addenda. And then once you've got that done, we recommend taking a risk-based approach to your customer base and relationship base and executing SCCs in order of risk.
Great, thank you. All right, next question here is from Andrew. If I am understanding this correctly, the core reason for striking down Privacy Shield is concern over US government access to EU citizens' data and violation of their GDPR rights. So how can an SCC prevent this US government access?
So that its access is one aspect of it, but the other aspect of it is what's called effective redress. And Andrew, this is a terrific question, so thank you for asking it. And what that means is there a legal mechanism to dispute misuse of information by a controller or processor or by a government? And so the SCCs themselves, they seem like a piece of paper. How are they going to stop the CIA from accessing your information, hypothetically? But what they do is they give people standing to assert legal defenses in court if there is a perceived violation. And we think that is important. But you're absolutely right. SCCs alone are not enough. That's why we've been focusing on sort of SCCs plus some adequacy determination, particularly looking at the use of encryption. So if you're sending data to a processor, are they using appropriate encryption in transit to transmit that information between the European Union and the United States? That might be one component of that. And you can build that into an agreement with your sub-processor or processor. But again, you're certainly correct. Intelligence is part of the question and will be a central part of the debate going forward. But the real component from the CJEU point is there adequate judicial redress? And you can create that through contract. You can create that through an SCC.
Great, thank you. Our next question here from Raymond. We are a SaaS company that serves as data processor to our clients and stores data in AWS US. Whom should be the party that initiates the execution of the SCC?
So if I understand the data flow here, your customers are, let's just say hypothetically in Europe or wherever, they're the controller. So they are typically what's considered to be the data exporter under the SCC framework, and you would be considered the data importer if I'm understanding your business model correctly. As either party can initiate the discussions of the SCC, we typically recommend being proactive because it signals to your customers, hey, we're privacy focused, we understand what's going on, you may have concerns and we're ahead of them and we're delighting you with our service. But again, either party can initiate the process. And it's not a data exporter has to start it and then data importer has to approve it. As long as it's executed and signed and binding on both parties, it's effective. So we recommend being proactive, and that's what we've been trying to do is get out there and be as proactive as possible with our user base about signing SCCs.
Great, thank you. We have a question from Mark here. Mark, I'm sorry, it looks like it came through in a couple different chats, so apologies if I get this wrong, but he said, we're running global systems storing PPI data held within the EUDC. Do we need to review our NA office's usage of this system now?
Great question. So if I'm understanding correctly, you've got a data center in the European Union, but you have resources in other countries, particularly the United States, perhaps, or North America, that are accessing that information stored in the European data center. The short answer is that very likely is processing under the GDPR. Article 4 is the definition of processing. Basically, it means any action on any data whatsoever. And assuming that the data that they are working with is personal data, also defined under GDPR Article 4. They are engaging in a data transfer and they are processing information across borders. And so, again, taking a risk-based approach, I don't know what data they're looking at. I don't know what they're doing with it once it gets to North America, but it sounds like it could be relatively low risk. And so we would suggest that you execute what we call an inter-affiliate data sharing agreement or global data sharing agreement, where your North American entity and your European entity sign SCCs between themselves. That's really the standard for this if you can't do what are called binding corporate rules, which very few companies have been able to do effectively for a variety of reasons. But the best practice here is to create an inter-affiliate sharing agreement, which is a legal document binding your various entities together so that they can transfer data freely amongst themselves.
Awesome, thank you. All right, our next question here. Many cloud services such as webinar systems, CRM systems, email marketing providers, etc., do not provide a direct one-to-one named and signed data processing agreement for their customers. so they rely on their terms and conditions. I've read somewhere that I need a named and signed DPA agreement that includes my company name and their company name personalized to my company. Is that correct? Or can I rely on their terms and conditions and privacy policy if they say that it is their DPA, et cetera?
These are great questions. And I think the best way to answer it is it's kind of to be determined. The SCCs have not been in this much or this bright of a light really since they were formed. And they are going to be changing. So the European Data Protection Board has signaled that they want to change the SCCs. We've seen a couple of variations on this. Is there specific guidance requiring that they be signed? No, but there is specific guidance requiring that they are binding on the parties who are transferring the data. And so we've seen a couple of species of this. One is you do what are called deeds of accession. So company has a blanket SCC, and then everyone who participates with that company agrees to that SCC, so that creates a binding contract. There's a manifestation of assent. And then any sub-processors come along and they accede, which is through another legal form, to that SCC. So let's say you've got a standard contractual clause on your website, and you tell everybody, hey, if you are agreeing to this, check this box. They check that box, and then all of your processors, sub-processors, vendors, joint controllers, they would sign a deed of accession to your SCCs, which would bind them to that document that your data subjects agreed to. That's one structure. Lots of these are going to be explored in the coming weeks, but that is one potential structure that you could go through. As to your point, does everybody need to sign it? Do you need to be specifically named? Again, the jury's still out on that. Under the European Union law, you can have a contract through adhesion. You can also have a contract through a non-signature, some manifestation of assent that's electronic or digital. Those are defensible. However, if you're talking about consumer to business or business to consumer relationships, that gets murkier. There's a lot there to unpack. And so if you do have questions, that would be a great thing to take to a private or a company lawyer who specializes in that space to get a really robust answer for your company.
Great. We have a really great question here around staying up to date. So what's your recommendation for staying up to date with all these changing regulations, and how can a business navigate the changing environment? And continuing that, without the Privacy Shield framework or certification, are there any other certifications, policies, leadership investments, et cetera, that could help a company indicate that they're a trustworthy partner who's keeping compliant?
Yeah, so to take your first question, how to keep up with things. So this has been the central problem of my entire practice. So I've been practicing privacy law for 10 years, and it's been a challenge. How do you keep up with all that is going on and all these ancillary things that can happen? So I use a couple of sources, maybe unorthodox, so take it with a grain of salt, but I rely heavily on Twitter. I think Twitter is a great source for sort of real time, hey, something's happening, something's bubbling up, and I follow as many hashtags as I think could be relevant in this space. I also use podcasts a lot. So I tend to listen to podcasts in the national security space. I tend to listen to podcasts in the US around legal issues and things of that nature. I rely on something called the IAPP, which is the International Association of Privacy Professionals. They have a great website that will periodically update news alerts and things of that nature. And then as an in-house practitioner, I'm fortunate enough to have some tools that are for sale. These are purchase services from a variety of service providers that will also provide more in-depth insight, more robust monitoring. But obviously Google News is a great feature, the New York Times, the Washington Post. But I think if you are going to be attention to this area, it is a significant part of one's job is how do you know what's coming down the pipe? And those are some of the tools that I've used. I'm sure there's others, but that's what's worked for me. In terms of, I'm sorry, what was the second part of the question? I got a little little
Yeah.
lost reminiscing about my podcast.
No worries, no worries. The second part of the question is how one can demonstrate that they're a trustworthy partner who's keeping compliant in the space in the absence of any formal certifications or leadership investments.
Yeah, so actually I think there is a certification that was just sort of flew under the radar, and a lot of people didn't hear this, but the French Data Protection Authority, they're called CNIL, they have issued an opinion back in, I want to say it might have been September, maybe August, that the International Standards Organization's 27701 standard, and this is a data protection, privacy specific standard, was really a hallmark of a company that took data protection seriously. And so if data protection concerns are top of mind to your management and to your user base, you might really want to consider finding an ISO certification partner and pursuing that 27701 certification. That would be a great way to signal your compliance. I also think that going back to that proactive approach that I was mentioning earlier about reaching out to your customers, offering to sign SCCs, looking proactively at the data at risk, looking at your architecture and how to reduce risk to potential data protection violations could be extremely valuable. And finally, just a self-plug, do lots of webinars because people like to listen to webinars.
Yes, excellent. Thank you. All right, next question here is, are EU modal clauses standard SCCs? And is this what Mixpanel offers or will offer to its customers in light of this legislative ruling?
Yeah, we will be offering SCCs to customers who are interested in it. And then we also offer data residency. So there are two options. But yes, SCCs is what we will be relying on going forward.
Great. All right. Next question here, and we have time for just a few more. How will third parties or cloud providers that store data in the US be impacted by this? Are any providers excluded from requiring a DPA or SCCs? In particular, cloud providers that store only login details for admin accounts, but no other personal data. Think SurveyMonkey to collect anonymized surveys. The only data is the personal data to log into the survey.
Yeah, so a first principle of the GDPR is it applies to the collection and processing of personal data. So if you're comfortable that they are not collecting or processing personal data, the Schrems decision, the GDPR itself, the e-privacy directive, all of those rules that we spend so much time fretting about do not apply. So if you can have an effective anonymization strategy, a lot of these concerns are very low. That said, the decision applies to data transfers out of the European Union to the United States. So if a cloud service provider is based in the United States and you're based in, let's say, Belgium, and you want to send them personal data for storage or processing of any kind, this decision certainly applies, and they would need to sign some form of agreement with you. This case hints strongly that those should be model contractual clauses put out by the European Commission. We call them SCCs, or standard contractual clauses. The point on the DPA is a little bit different. So the DPA is a product of something called Article 28 of the GDPR, and that spells out what processors need to agree to do to support a controller. So here that could be you, in order to make sure that the information is processed in accordance with the GDPR. And so that the controller, again, that could be you, meets all of its obligations under the GDPR. So they're two different animals. One is getting information out of Europe into the United States or wherever. And then the other one is processing information and what types of controls are required. Both are premised on the processing of personal data. So if you have an anonymization strategy, you can avoid those use cases.
Great, thank you. All right, we have time for just one more question. Before I give you that question, for our audience, we would love your feedback. So I'm going to post in the chat window a link to a survey, if you could provide it. Also, just a reminder that this session was recorded, and we'll be sharing out that recording as well as the slides within 24 hours. In that email, you'll also find a link to our community QBQ, where you can continue asking questions and viewing responses from Peter and the rest of the security team at Mixpanel. So be on the lookout for that email within 24 hours. All right, and with that, our last question is, how will third parties, does it help if companies use geolocation storage to store EU or US data in separate databases and use aliases in the application, but data is still under control of the same company, the same people, and the same AWS cloud?
A terrific question. So if I'm following, you're looking at a cloud environment where you would identify and shard out EU data subjects and US data subjects, and you would keep their information separate, but they would still be subject to the same sort of overarching access controls and restrictions. So there are a couple of questions there I would consider, and this is a very technical question and one I'd love to dive into, but some things to consider. One is, where is that company that's doing the access? Is it based in Europe? Is it based in the United States? Two, are the access restrictions in line with European data protection practices? Three, I would consider, is it worth the risk introducing that level of complexity? Because you're going to tell customers, we keep it separate, we treat it differently, but given the fact that they're on the same systems, the same premises, and the same control environment, but they're in different compliance stacks, the chance of data intermingling between the two and running into a problem could be quite high. Again, that depends on your technical solution, but that is a risk. And then finally, and going back to the Schrems case, how are you getting the EU data into AWS? And if it's still being transferred, if it's being transferred according to SCCs, or if it's being transferred according to what is the now invalid privacy shield, what types of protection do you have in place for that data transfer to occur, and what is the risk there? So again, it's a fantastic question and a really thorny one, but it's going to depend on the details. But some things to think about are those 4 points I've just laid out. I did want to, just in conclusion, I'm just going to pass along some additional resources, and this will be in the deck, which will be shared. But there was a question earlier about how do you stay on top of things. These are just some additional resources for you all to read, or to point your compliance team or legal team to. I've linked here to the Schrems decision and a couple of other key regulators. Again, this was written yesterday morning, and there's already some additional ones that I would put on here, but this is a great place to get started. So I think that's all the content I have.
Awesome. Well, thank you so much, Peter, for sharing all this information. Very valuable. And thanks to our audience for all the awesome questions. Again, if you could take a few moments to fill out that survey, we'd really appreciate the feedback. And we will look forward to continuing the conversation on QBQ. So thank you, everyone, and have a great day.
Thank you, everyone. Goodbye.